Good morning. I'm going to consider today the case of Shevill and Presse Alliance, a case involving personality rights and more particularly libel, decided by the European Court of Justice in 1995. First, let me set the context. The case was a preliminary reference to the European Court by the House of Lords, at that time the Court of Final Appeal in the United Kingdom. It concerned the interpretation of the Brussels Convention on Jurisdiction and the Enforcement of Judgments of 1968, a regime which exists today in slightly modified form in Regulation 1215 of 2012, the Brussels I recast regulation. Now, as is well known, the 1968 Convention established a system of jurisdictional rules under which a defendant in a civil or commercial matter was to be sued in the state of their own domicile, but which also provided alternative grounds of jurisdiction for different types of case. By what was then Article 5.3 and is now Article 7.2, the Convention provided that a defendant domiciled in one contracting state could be sued in another contracting state in matters relating to tort, delict, and quasi-delict in the place where the harmful event occurred. That's the concept, the place where the harmful event occurred, which was the subject of the Shevill case, and indeed of many other cases that have come before the European Court. Back in 1976, in the Beer case, the European Court had ruled that the place where the harmful event occurred in Article 5.3 could be either, at the option of the plaintiff, the place where the wrongful act occurred, or the place where the damage was suffered. But that was in a case of physical damage. How did that apply to defamation? The facts of the case were these. Fiona Shevill was a student who came from Yorkshire in the north of England. She got a summer job in 1989 for a few weeks working at a bureau de change in Paris run by Checkpoint, SARL. The Checkpoint group of companies was set up by a Mr. Felix Grovit, who was a prolific litigator in the 1980s and 1990s, and who in other judgments was the subject of robust criticism in the courts. I'm sure many of you will be familiar, for example, with Turner and Grovit, a case in which the European Court ruled that anti-suit injunctions are contrary to the Brussels regime. But that is a story for another day. In September 1989, the Paris evening newspaper France Soir published an article alleging that Checkpoint, SARL, was involved in money laundering the proceeds of drug sales, and the article named Fiona Shevill. Now, what happened next is that Fiona, along with Checkpoint, SARL, and other related companies, and doubtless with their backing, brought libel proceedings in the English courts against Presse Alliance, the publishers of France Soir, relying on Article 5.3 of the Brussels Convention. They asserted that the English courts had jurisdiction on the basis of the publication of France Soir in England. It was estimated that 237,000 copies of the newspaper were sold in France, but only 230 in England, of which just 5 were in Yorkshire. Fiona argued that England was the place of the harmful event because that is where she suffered the damage to her reputation. Well, of course, that jurisdictional assertion was challenged on the basis that no harmful event had occurred in England. The challenge was unsuccessful at first, second, and third instances, but on a further and final appeal, the House of Lords referred 7 questions to the Luxembourg Court for preliminary rulings. The case came initially before the 6th Chamber, which considered written and oral submissions and the opinion of Advocate General Darmon. But instead of proceeding to judgment, the Chamber then referred the case to the Grand Chamber, which reopened the oral procedure and in turn received further oral submissions and the opinion of Advocate General Léger. Having 2 opinions was the most unusual thing to happen, both then and now. Advocate General Darmon pointed out the problem that arose where the place of the harmful event occurred was hard to identify, particularly where multiple places could be said to be the place where the harmful event occurred. He cited national law and academic authors from various member states and noted that there was a diversity of solution to this problem. Authors from Germany and elsewhere argued that compensation for all the harm suffered by a claimant should be available from the courts in the place where any of the harm was suffered. This is what you might call a wide reading of Article 5.3. It's also, incidentally, an approach which is now clear is taken by English domestic law. By contrast, French law, for example, drew a distinction between jurisdiction for invasion of privacy by the press, between, on one hand, courts for the place of domicile of the defendant, and those for the place of causal event, and on the other hand, for the various places of distribution of the offending material. The former, that is the courts for the place of the causal event and the place of domicile, had jurisdiction to award compensation for all the damage suffered by the plaintiff wherever that occurred, while the latter, the place of distribution, the courts for the place of distribution, had jurisdiction to award compensation only for the damage suffered within those courts' local districts. Now, this solution for breach of privacy was favored by distinguished French authors for cases of defamation. Advocate General Darmon, in the first of these opinions, also pointed out that allowing the courts of the victim's domicile to have jurisdiction to award compensation for the whole of the damage suffered was tantamount to creating a jurisdiction based on the plaintiff's domicile, what the private international lawyers call a forum actoris, which is contrary to the guiding spirit of the Brussels regime that emphasizes the defendant's domicile, the forum rei. Time and again, in the case law of the Court of Justice of the European Union, you see it drawing back from solutions which tend towards a forum actoris. So, Advocate General Darmon proposed a dual solution, namely that courts of the place of causal event, the printing of the newspaper, should have jurisdiction in respect of all of the damage, but those of the place of distribution should have jurisdiction only in respect of harm suffered within their territorial jurisdiction. Advocate General Léger, in the second of the opinions, agreed. He too pointed to the need for a restrictive interpretation. After all, Article 5 was an exception to the general rule of the defendant's domicile in what was then Article 2. And he rejected the United Kingdom's argument that the harmful event was the initial communication of the defamatory statement. Both advocates general rejected the argument that their proposed solution would lead to inconsistent judgments between different member states. Given the strong lead taken by both advocates general, it's not surprising that the Grand Chamber followed that lead. Answering 4 of the 7 questions together, the court held that the jurisdiction to award all the damage lay with the courts of the state where the publisher was established, which would usually be the same as its domicile, so would give rise to jurisdiction under the general rule against the publisher as a defendant. But also, it would give jurisdiction to the state where the victim claimed to have suffered injury to his, or in Fiona's case, her reputation, which would have jurisdiction to rule solely in respect of the harm caused in the state of the court seized. So the so-called mosaic principle was given a place in European law. It's called mosaic because a mosaic needs lots of little tiles to make up a whole picture, and a victim of libel in an international publication who doesn't want to sue in the defendant's home state may need a whole lot of claims to recover compensation for the whole of the damage to their reputation. But there was a second aspect of the court's decision which has lain below the radar for almost 30 years, but which has recently found a new and strange resonance. In addressing the remaining 3 questions, the court went on to consider whether, in deciding whether it had jurisdiction as the court for the place where damage occurred, the national court needs to look beyond the national law, which defines the criteria for establishing whether the event in question is harmful. And although it doesn't quite say so, at least in the English language version of the judgment, I think it is asking whether the convention contains its own concept of harmfulness for the purposes of Article 5.3, or whether that remains solely a question for national law. The point arises from the fact that a claim for defamation in English law does not require proof of loss, although in a sense, I suppose you could say that defamation necessarily connotes a damaged reputation. And that indeed, the question of what constitutes harm or loss is key to this issue. What the court decided, in short, was that these are matters solely for national law as determined by the conflict of law rules of the forum, provided that the effectiveness of the convention is not thereby impaired. Now, let me just divert for one moment to mention the case of Hrvatska Šuma, I hope I pronounced that correctly, case 242 of 2020, decided as recently as the 9th of December 2021, which is where we find the strange resonance of the second point in Shevill. In that case, the court, following the opinion of Advocate General Salgsmansgaard Øy, held that a claim for unjust enrichment did not fall within Article 7.2 of the Brussels I recast regulation, because it presupposed the existence of an unlawful event which caused damage to a victim. He considered the question of what constitutes a harmful event and considered that as a necessary criterion under European law for the application of the article. Now, and the court took that view. The decision has been widely, but not universally, criticised in academic circles, and I don't propose to get into it now, beyond noting that neither the Advocate General nor the court mentioned the ruling in Shevill that the criteria for deciding whether there was a harmful event were solely a matter for national law. Shevill has, however, not been forgotten in the case law of the court, and I propose to mention just 4 cases in a thread in the time left to me. First, in the joined cases of E-Date advertising against X and Martinez against Mirror Group newspapers, decided in October 2011, the court had to consider 2 cases of alleged infringement of personality rights. In the E-Date case, the right of a convicted murderer to have his identity kept secret, and in the Martinez case, the right of a well-known actor to privacy in relation to his alleged relationship with well-known celebrity Kylie Minogue. The issue was about how the place where the harmful event occurred or may occur, and how that's to be interpreted where the alleged infringement involves publication on the internet. You can see that these cases coincide in point of time with the burgeoning use of the internet in our lives. Now, the court drew attention to its decision in Shevill, but pointed out that publication on the internet is different from publication in the regional distribution of a newspaper, in that internet publication is intended in principle to be accessible anywhere and irrespective of the publisher's intention as to where it should be read. So a criterion based on distribution isn't really useful in the context of the internet. Now, in a modification of the mosaic principle, the court came up with a somewhat different hybrid solution. It held that a claimant in this situation had the option of bringing proceedings for all of his damage, either in the court of the defendant's domicile under Article 2, which is now Article 4 in the latest version, or in the place where the center of his interests is based. That's the center of the plaintiff's interests. And in the case of natural persons, the center of their interests is normally the place where they have their habitual residence. The claimant also has the option of suing in one or more member states for damage caused locally in each of those states. So in this context, the focus on this new idea of the center of his interests as a connecting factor, you can see the court inching towards allowing a forum actoris. Now, please note that the E-Date decision applied to natural persons and was at least partly based on the desirability and the interests of the administration of justice of affording access to justice to such persons for all of their damage in a single forum. Our next case is Bolag Supplyslingen, decided in October 2017, in which the court had to consider the application of the E-Date principle to a legal person rather than a national person. In this case, the Estonian claimant alleged that the Swedish defendant had added its name to a blacklist published on the defendant's website, alleging that the claimant had engaged in acts of fraud and deceit. The claimant said that this information was false and damaging to its business in Sweden. The information was in Swedish, and when the proceedings came before the Estonian court, the court held that the information could not be generally understood by Estonians and that there had therefore been no damage in the state of the claimant's seat, although it's not clear whether Estonia was not only the claimant's seat, but also the centre of its interests. The National Court therefore asked the European Court for clarification about the status of legal persons for this purpose and for the criteria by which to judge the location of the centre of the claimant's interests. It also asked about its jurisdiction to order the rectification of the content of the Swedish website, which of course was in a different member state. The European Court said that the centre of interests of a legal person carrying out economic activity is the place where its commercial reputation is most firmly established and must be determined by reference to the place where it carries out its main economic activity. It held that the location of the claimant's registered office is not conclusive for the purposes of that analysis. It also ruled that the mosaic principle did not apply to a claim for correction and removal of the website content, and that courts of each member state where the information on the internet was accessible, that is, those which only had jurisdiction to award compensation for local damage, could not make an order of that sort for correction and removal. Now, of course, there are always questions left unanswered by such a ruling, and one such question arose in our next case, Mittelbayerischer Verlag against SM. The defendant was the publisher of a regional German newspaper in Bavaria, and the case concerned an article published in 2017 on the paper's website, and it told the story of a Jewish Holocaust survivor, Mr. Israel Hoffman. He had been born in Poland, and during World War II, he was incarcerated in several concentration camps, including the notorious Auschwitz. After the war, Mr. Hoffman had settled in Germany, and the story concerned the name of his third child, born in 1961. He and his wife had wanted to call the girl Fire, but the local registrar refused to register the girl's birth in that name on the grounds that it sounded too foreign and could not be pronounced in German. And I don't speak good German, and I'm not sure whether that's a sound reason, but at all events, that was the reason given. The newspaper reported that Mr. Hoffman had chosen the name because it had been the name of his sister, who had, as the story originally put it, been murdered in the Polish extermination camp of Treblinka. Now, Treblinka, of course, was in Poland, but it had been established and administered by Nazi Germany. Now, within hours of the publication, the Polish consul in Munich had raised objections to the phrase Polish extermination camp, and it was corrected by the newspaper to read, was murdered by the Nazis in the German Nazi extermination camp in occupied Poland. Now, the claim, and this is a peculiar feature of it, was not brought by Mr. Hoffman. For all I know, he may no longer have been alive by 2017, but by a Polish claimant who lived in Warsaw and who was involved in activities aimed at preserving the memory of victims of crimes committed by Nazi Germany against Polish nationals. He claimed that his personality rights, in particular his national identity and national dignity, should be protected by an order prohibiting the defendant from using the term Polish extermination camp in any language in referring to the German concentration camps in occupied Poland. He also sought a published apology and an order for payment to a fund for the Polish victims of Nazi prisons. He placed reliance on the E-date judgment to found jurisdiction in Poland as being the center of his interests, and the defendant, needless to say, challenged the jurisdiction. That challenge eventually wound up in the European Court. By the time it reached the Luxembourg Court, the jurisdictional issue had become refined somewhat to the question of whether center of interests criterion could be relied on only if the published content made it possible to identify the claimant directly or indirectly as an individual. The European Court pointed out that at the time of publication, the defendant would not be in a position to know, that's the publisher, would not be in a position to know the centre of interests of a person who was not identified directly or indirectly in the content posted on the internet, who might claim that their personality rights had been infringed, and that would run counter to the requirement that the rules of jurisdiction be predictable. So the European Court held that Article 7.2 jurisdiction to award compensation for the entirety of a claimant's damage, the jurisdiction of a court for the place of the centre of a person's interests, only applied if the content of the material placed on a website contained objective and verifiable elements which made it possible to identify directly or indirectly that person as an individual. And that brings me then to the last of our thread of cases, which was decided just before last Christmas on the 21st of December 2021, namely GT Flix TV against DR. Now, by contrast with the high seriousness of the Holocaust, which formed the backdrop of the Mittelbayerische case, this one occupies the opposite end of the scale, namely pornographic films. GT Flix was based in the Czech Republic and produced and distributed pornographic TV programs, including via its website. DR was an individual domiciled in Hungary who produced, directed, and distributed pornographic films of his own, marketed via his websites in Hungary. The Czech company, GT Flix, alleged that DR frequently made disparaging remarks about it in various websites and forums, and requested that DR withdraw its disparaging remarks. When DR failed to do that, GT Flix filed proceedings against him, not in Hungary and not in the Czech Republic, but in France, asking for an order requiring DR to cease making disparaging remarks about it, removal of the remarks, and related relief, including nominal compensation for economic and non-material loss. And DR, in turn, disputed the jurisdiction of the French court. The Advocate General, Hogan, and the court both reaffirmed the Bolag supply-Sningen principle that the jurisdiction to order rectification and removable, which is an indivisible claim, could only be brought in the courts of the defendant's domicile or those for the centre of the claimant's interests. But they differed from each other about whether other courts could award compensation. The Advocate General proposed a narrowing of the Mosaic principle, so as a court could only hear a case for non-material economic damage caused in the territory of that court if the claimant could demonstrate that it had an appreciable number of consumers in that jurisdiction who were likely to have access to and to have understood the publication in question. But in this respect, the court did not follow the Advocate General's lead. It again recalled its earlier decisions from Shevill onwards and reaffirmed that the jurisdiction of the courts of each member state to award compensation for local damage depended solely on showing that the website content is or was accessible from that member state. So it was accessibility rather than the actual likelihood of it being accessed, which was the criterion for the Mosaic jurisdiction. I should add in parenthesis that there are some rather surprising elements in the judgment, which we don't have room to explore here, but which have been pointed out by Marco Buzzoni on the blog of the European Association of Private International Law. One of them is that under French law, disparagement, which was the cause of action relied on by GT Flix, is not characterized as a breach of personality rights, but as an act of unfair competition. Now, this raises the question whether the judgment may be read as extending the Mosaic principle beyond the sphere of personality rights into general economic rights. Another aspect is an apparently unqualified remark that a claimant must always be able to bring proceedings before the courts of the place where damage occurred. And this stands in contrast to some of the European Court's other recent case law on Article 7.2, which emphasizes predictability of its jurisdictional rules. There seems, as ever, to be a tension in the case law between the arguments for and against a forum actoris. So where does that leave us? It leaves the Mosaic principle alive and well in the application of Article 7.2 to at least for compensation for infringements of personality rights, whether by publications in newspapers or on the internet. And it leaves the claimant who wants to claim all of his damage, whatever suffered, and or who wants to obtain an order for the correction or removal of the offending material, with the option of suing a defendant either in the state of the defendant's domicile or in the state of the center of his own interests. Is that satisfactory? The interpretation of Article 7.2 is debated quite widely in academic circles at the moment, and the one thing that seems to be agreed by all commentators is that this all needs legislative reform. I'll leave it for you to judge whether it's satisfactory and for the European Commission to consider in its review of the operation of the Brussels I regime. The recast regulation requires that the Commission conduct a review and communicate it to the other institutions by the 11th of January this year. That's last month. But as far as I'm aware, there's no sign of it just yet. Thank you very much for your time and attention.